Okay, I've been narrowing down my information, the discovery for my case in West Milwaukee. My next hearing is in September. I got like deadline for some homework that the judge has assigned to me, which involves my discovery, and I really have to fight to see these body cams, apparently, because the cops want $600, and the judge set up a hearing for that. The prosecutor is downplaying this $600 thing, and the prosecutor is saying I got to go to the cops for my discovery, even though he can look at his computer and see it. He says that I'm not privileged to what he's got. So I have argued that there is a hardship with the discovery from the police, the West Milwaukee police, and that hardship is the $600, $600+. So I'm learning about discovery, which, I mean, they're focusing entirely on civil procedure, and I gotta say that reading all this civil procedure for discovery, I'm not seeing any cases that they cite. All these cases in here have nothing to do with trespassing, have nothing to do with any kind of criminal charges with the police. It's all just organization against organization, or maybe a government entity against an organization. There's no cops against an individual as cases cited, yet we are working with civil procedure. I've never seen this before, but I mean, I'm going through it because I got a big fight just to get some discovery, which I've been denied since, I can't remember when I got arrested. April, May 30th? I kind of forget, because yeah, it was June for outogamy, June 30th for outogamy, and then Milwaukee was at least a month before that. So we got 804.01 general, and I narrowed this down a lot. General provisions governing discovery methods. Parties may obtain discovery by depositions upon oral or written questions, written interrogatories, production of documents or things, and requests for admission. Unless the court orders otherwise, the frequency of use of these methods is not limited. But then later they say that there is limitations further down. Scope of discovery. The scope is as follows. Parties may obtain discovery that is relevant to any defense and the needs of the case, considering the importance of the issues, the controversy, the parties' access to relevant information, the parties' resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the discovery outweighs its likely benefit. Information within discovery need not be admissible in evidence to be discoverable. I think there was at this point where the outogamy prosecutor argued that he didn't want to pursue my case any longer and dropped that case, because he seemed to take in a lot of what was mentioned here about the cost and the importance, the low-level grade criminal charge and all of that. And that's for discovery, whether to release it or not. The judge, because the prosecutor is saying he's not going to give me any of his discovery. He gets it for free. I got to pay $600 for it. It's not fair. But yeah, that's where the outogamy prosecutor stops. But West Milwaukee is pushing further with this. We're going to hearing number 2, and that's the bigger fight. Limitations. Upon the motions of a party, the court shall limit the extent of discovery if it determines that discovery is duplicative or can be obtained from some other source that is more convenient, less burdensome, or less expensive. Well, the less expensive solution is through the prosecutor. But I think I'll request the form for indigency to be approved to be an indigent, and then get my costs waived. So I'm going to fill out that form. So that's another way to go about it. But right now, the lesser cost is through the prosecutor. The burden of expense of the discovery outweighs its likely benefit or is not proportional to the claims and defense at issue. The amount in controversy, the parties' resources, the complexity and importance of the issues at stake, and the importance of discovery in resolving the issues. Trial preparation materials. A party may obtain discovery of documents for another party only upon showing that the party has substantial need of the material and that the party seeking discovery is unable to obtain the materials by other means. So that means I can ask YouTube viewers to request discovery from my prosecutor as well. It's not just me. I don't need just a lawyer. I can ask any other party. Since we're working within the civil action, I can ask anybody on YouTube to submit a discovery with the court, asking for materials, and you would be asking on my behalf. Trial preparation, let's see. A party is not required to provide discovery of any electronically stored information absent a showing of substantial need and good cause. So to get those body cams, I need to show a substantial need for them and good cause. Data that cannot be retrieved without substantial additional programming or without transforming it into another form. Backup data that are substantially duplicative of data that are more accessible elsewhere. Let's see. Undue burden or cost. In response to a motion to compel discovery or for a protective order, the party for whom discovery is sought is required to show that the information is not reasonably accessible because of undue burden and cost. Getting those police body cams are an undue burden and cost. If the police are charging $600, but all the other police stations in Wisconsin that have asked for their body cams with, they give it for free. And this police station has Axon Body Cam 4, but they say they're not paying for the program that I could get a link to download their body cams with. They want to charge $600 and give me a CD. It seems like the undue burden is by design to make hardship for people requesting the body cams. If that showing is made, the court may order discovery from such sources only if the requesting party shows good cause. The court may specify conditions for the discovery. No party may serve a request to inspect electronically stored information or respond to an interrogatory by producing electronic information until after the parties confer, unless excused by the court. So we have to get together and meet, judge, me, and prosecutor, and talk about these body cams. That's about the only electronic stored information is the body cam. And then we talk about it, and it makes sense to discuss it beforehand instead of the prosecutor assuming things, and it's explained here. The subject on which discovery of electronical information may be needed, when discovery should be completed, and whether discovery shall be limited to particular issues. To my rest, I think particular means just from the whole engagement with me and the cops until we no longer are engaging. Preservation of electronically stored information pending discovery, the form in which electronical information shall be produced. All right, I would ask not to have a CD. So we confer, and that's what at the conference is where I say I don't want a CD, and I'll see how they react to that. I want a link like what Axon provides. Get with the program. The method for asserting claims of privilege or of protection of trial preparation materials, and to what extent, if any, the claims may be asserted after production of electronical information. The cost of discovery of electronical information and the extent to which such discovery shall be limited. If a party fails to confer, any party may move the court for relief. And that would be maybe a sanction saying, if I can't get these body cams, I got to pay $600 for the police to give them to me, and the prosecutor refuses to give me those body cams, then they shouldn't be allowed, they shouldn't be put into evidence at all. Okay, they shouldn't be allowed in court if I'm being denied. And I mean, I've been getting denied this whole time for months. And then what, they're gonna spring on these long videos, because they're probably an hour, and that's 2 body cams with the 2 officers, and I've been waiting months and months on this, and the prosecutor's gonna argue that, oh, I got my own video, but I was separated from my cameras, and a lot of the conversation can't be heard. If after conferring any party objects to any request for discovery of electronical information, the objecting party may move the court for an order, protective order. Upon motion by a party from whom discovery is sought and for good cause shown, the court may make any order which justice requires to protect a person from annoyance, embarrassment, oppression, or undue burden or expenses, including but not limited to one or more of the following: that the discovery not be had, that the discovery may be had only by specifying terms including time and place, or the allocation of expenses for the disclosure of discovery, that the discovery may be by a method other than that selected by the party seeking discovery, that certain matters not be inquired into, or that the scope of the discovery be limited to certain matters, that discovery be conducted with persons designated by the court. So like, yeah, just only certain people can see it. So I can't get copies of the body cam or the report. If the motion for protective order is denied, the court may order that any party provide discovery. Motions under this subsection may be heard. Timing of discovery, unless the party stipulates or the courts upon motion shall not operate to delay any other party's discovery. And that's what they're doing, they're delaying. A $600 fee is a delay, okay? And that's prejudice. That should be a case dismissed right there. Supplementation of responses. A party who has responded to a request for discovery is under no duty to include information thereafter acquired, except as follows. A party is under a duty to all of the following: the identity and location of persons having knowledge of discoverable matters, the identity of each person called as an expert witness. A party is under a duty to amend a prior response if the response was incorrect. A duty to supplement responses may be imposed by order of the court, agreement of the parties, or at any time prior to trial through new requests for supplementation of prior responses. Custody of discovery documents. The original copies of all depositions, interrogatories, requests for admission, and responses thereto, and other discovery documentation shall be retained by the party who initiated the discovery. The original copy of deposition shall be retained by the attorney from the person recording the testimony until I have to keep all that stuff in my car. All right, as this is going along, I'm keeping the tickets, and it's a burden for space in my car, and now I have to collect more documents and stuff for my coming trial in West Milwaukee. The court's power to control the discovery process is sufficient to prevent abuses. So they're happy with the court's power. If the parties confer before embarking on discovery, they may reduce the ultimate cost. And yeah, if they want to give me a CD, if we didn't discuss this, like in Natchitoches, Louisiana, I was given a CD in court, and I told them I don't have a CD player. Well, that's because the prosecutors was acting very dumb, assuming I could use a CD. I could write a CD on my computer, and he was assuming that. And even when I said I didn't have one, he still said, well, if I can use YouTube, I can use a CD player on my computer. I don't have, just because YouTube's a software and the CD player is hardware, I don't have hardware. So that's good. And at least in Wisconsin, they say we should confer, but this is through civil action, not criminal. But in Louisiana, they just assume the prosecutor assumes you got everything. But yeah, this is Wisconsin. The rule does not require parties to confer before commencing discovery, but it's a good idea. Depositions upon oral examination, depositions upon written questions, interrogatories to parties, requests for admission. These discovery devices, if employed before serving a request for production or inspection of electronically stored information, may lead to more informed conferences about the potential scope of such discovery. So before I get the body cams, they're saying I should get the depositions, I should get the request for admission. I don't know what that is. It sounds like it's a bill of particulars. Interrogatories, I should get the interrogatories before I get the body cams. It's like, it sounds like, I mean, that's the only electronical thing I'm looking at getting is the body cams, and that's electronical. So I'm assuming when they say electronic information, I'm assuming body cams, video, which I would think watching the video first, then conferring second would be the order, the proper order, but they're saying confer first, they get the body cam second. That's the rule for Wisconsin. The specificity of the discovery request, the quantity of information available from other and more easily accessed sources, the likelihood of finding relevant, responsive information that cannot be obtained from other, more easily accessed sources, predictions as to the importance and usefulness of the further information, the importance of the issues at stake in the litigation and the parties' resources. So they've said several times that I should be getting the information from other sources, and what they're saying is they're not saying don't get information from the prosecutor. They're not saying that. They're just saying get it from other sources. Well, why can't the other sources be the prosecutor? Okay, they're not saying don't get information from the prosecutor. They're just saying get information from other sources, but without saying that the prosecutor is not one of those other sources. We're just supposed to assume that. What is the other sources? Okay, like what do they consider the primary source, and then what do they consider the other sources? And the municipal judge in West Milwaukee is making her interpretations as the other sources are anybody who's not the prosecutor. So, I mean, that's her definition of it, and I would like to argue even that. What is the other sources? What's considered the primary source? Because it's said a lot in here, and they're saying other sources are the police. Why can't police be considered the primary source, and the prosecutor be considered the other sources in Wisconsin according to this law? All right, that's about as far as I got. I still got, that's less than halfway through what I've talked about at this point.